Hi friends, I'm going to explain the concept of judicial review in Indian polity and constitution. Judicial review is nothing but the review done by the judiciary, which is nothing but the network of courts functioning in the country. Judicial review as a concept and as a feature was incorporated in the Indian constitution by borrowing this feature from the American constitution. Apart from this, the larger principle of independence of judiciary. This was also borrowed from the American Constitution. Judicial review evolved over the years and it also contributed to this process called judicial activism. In a separate video, I have explained about judicial activism in detail. Kindly listen to that video. You will get an in-depth idea about judicial activism. Now coming to judicial review. In a democracy, there are three major organs or pillars. The first organ or pillar is the legislature. Legislature is a law-making body. At the central level, we have the Indian Parliament. At the state level, we have various state legislatures. These are the law-making bodies. The second organ is executive. Executive is in charge of administering the country. It is in charge of running the day-to-day affairs of the country. Executive is involved in policy making and policy implementation. The third organ and the most important organ is judiciary. Judiciary refers to the network of courts in the country. The judiciary dispenses justice. It has to uphold rule of law. So they will hear cases and they will deliver justice. Judiciary will also interpret the law as well as the Indian Constitution. So this is the domain of the judiciary. Generally, judiciary will not step into the other two domains, legislature and executive. But the other two organs are accountable and answerable to the judiciary. That is why the judiciary is largely independent in a democracy. Now let's take a look at the actual process of judicial review. Under judicial review, the judiciary reviews the activities or the actions done by the executive as well as the legislature. If any law brought by the legislature or the executive is against the principles of the Indian Constitution, or if it is against the fundamental rights enshrined in the Indian Constitution, then the judiciary can declare such a law as unconstitutional and thereby as null and void. If a law brought by the executive or the legislature is against the values or principles or the basic structure of the Indian Constitution, or if it is against the fundamental rights enshrined in the Indian Constitution, or if the authority, either legislature or executive, is not competent enough to enact that law, then the judiciary can step in and declare the law as null and void. When we speak about law, the law can be an act of the parliament. It can be an act of a state legislature. It can be an order issued by the executive. It could also be a bylaw. So basically, law means any general rules laid down by either executive or legislatures. As already explained, it includes acts, general orders, and also bylaws. Under judicial review, important emphasis is given to the fundamental rights in our Constitution. Article 13 specifically tells that if a law is against the fundamental rights, If the law abridges the fundamental rights or if it takes away the fundamental rights from the citizens, it can be declared null and void. This authority is specifically given by the Constitution to the judiciary. There are two articles, Article 32 and Article 226. Article 32 gives authority to the Supreme Court. Article 226 gives the authority to the high courts. Under the writ jurisdiction, this authority is provided. Let me give some practical examples of judicial review to illustrate this better. Few years ago, the Supreme Court declared Section 377 of IPC, which criminalized homosexuality, as against constitutional principle. So, it held the law as unconstitutional. As such, currently the law, that is IPC 377, is null and void. The reason is it went against the fundamental rights, against right of equality, against right of individual choice. It was criminalizing certain people who were choosing their own choice of sexual freedom. Okay. Another example. In the past, the central government as well as some state governments in India have provided reservation to certain communities. But such reservations have been provided without substantiating it with adequate data to prove the socio-economic backwardness of that community. Such laws were later struck down by the judiciary. Here also, such laws were against the right to equality. In fact, reservation itself enforces right to equality. If a law is brought without backing it with quantifiable data, then such a law cannot be accepted. Apart from this, if a state legislature or the parliament enacts such a law without such quantifiable data, then it is not competent to enact such a law, is it not? Another example, this is regarding important values of the Constitution and the supremacy of the Constitution. In 1973, in the Kesavananda Bharati case, the Supreme Court upheld judicial review and also laid down the doctrine of the basic features of the Indian Constitution. According to this judgment, the Indian Constitution can be amended, but any amendment cannot change the basic structure of the Constitution. It cannot change the basic features of the Constitution. This is also an example of judicial review. Thank you.